thought that was this a way to bypass litigation? How would this impact them? Given the circumstances, my belief is that because of the convention, businesses are going to be a lot more curious about mediation, curious about how do I get my settlement agreement enforced. And what is going to happen is that the first question they are going to ask is, am I having this mediated in a jurisdiction that has ratified the convention? Do I need this enforced in a convention, in a jurisdiction that has ratified the convention? If not, how else? And the simple answer, how else I can get the settlement agreement enforced, will then lie in mixed, hybrid processes like the ARP protocol, like various international courts that have introduced mediation so that you can have a reciprocal enforcement of court judgments with the Hague Convention. And I think the use of these protocols will grow in the short term before we look at the mediation convention growing, but grow it will. So that is on the point of enforcement. The second point that I want to touch on, the second theme to touch on is, again, borrowing from what Alfred had already started on. One of the biggest challenges that the working group faced when they were discussing the mediation convention was standardization. There is today, as yet, no uniform way of mediating. It is not like arbitration, where there's quite clear procedural rules, though small nuances from seat to seat. One of mediation's strength has been its flexibility. And one of the challenges for practitioners has been, how do we balance this flexibility with the need to at least have some level of universality in the standards of mediation? And to a degree, I think this is where some of the geopolitics might start to influence things, in the sense that I think there will be different jurisdictions trying to impose their way of mediating as the way, the international way of mediating. I already experienced this dialogue going on. I do my trainings and I conduct my webinars, and I conduct co-trainings with trainers from the US, from different jurisdictions in Europe. I recently even had a session with a participant from Thailand, and it's been very interesting to observe that when a Singaporean says mediation, it is interpreted and understood in a very different way depending on what jurisdiction the listener is from. Because in Singapore, traditionally, we had adopted a very classical, very pure facilitative approach. And I think that is also common in India, it's also common in Hong Kong. But in some jurisdictions, including in Japan, in Korea, and actually increasingly so in Europe, mediation is something which is very linked to the courts and it's often associated with judicial mediations, where they are used to the mediators also being judges, and parties actually are used to, and they expect to hear some clues from the judicial mediator on what is the likely outcome if they couldn't get this settled and they had to continue in trial, what we know as evaluative mediation forms. And it used to be that these two camps, and there's yet another camp of transformative mediators, will all be selling their form of mediation as the way, and all other forms are wrong, unethical. I think what I am now coming to appreciate is that there are actually great strengths in all the different approaches, and there is a great need for this dialogue. And so again, my short-term prognosis for businesses is that if you do want to use mediation, recognize that there are different standards, and you will want to investigate and explore when you are proposing mediation, is the counterparty understanding mediation in the same way as you are? And is the mediator that you are choosing also understanding mediation in the same way as you are? And one of the skill sets that international mediators will need to have is this level of empathy and familiarization with how different mediation is, and to have that adaptability to morph your practice. And international, as I have learned from some of the best international mediators, some of the most sought after international mediators, and I had the privilege of doing this in my role as with the International Mediation Center. The top mediators are people who know how to adapt their practice. If you need me to be more evaluative, I can. If you're used to being more facilitative, I can. If this dispute is more emotional, I know how to apply transformative mediation to work with the parties almost as a coach. And businesses need to gradually understand that there are these nuances. And international mediators need to beef up the breadth of our competencies as much as the depth of the competencies in order to cater and to this expected growth and demand for mediation. Will we ultimately land on some international standards? My faith as a mediator and my fellow professionals is yes. I mean, if mediators can't come to an agreement, then very few other groups can, and I think we certainly must live up to our titles as mediators to be able to talk and collaborate and find something universal. In the very least, I think elements like confidentiality, elements like not imposing an outcome, even if we can guide parties with our experience, I think this will just form the foundational blocks of that standard practice, but that dialogue will need to happen. And the third theme that I want to talk about in terms of what it means for businesses is this theme of professionalization. Again, I don't want to steal Alfred's points, but I am going to borrow from that. That's a privilege of going first, Alfred. And that it's a privilege of me going second. I can just build on everything that you have shared. But and so Rajesh has the greatest difficulty to be original. But on Alfred's point, I agree that there's going to be a growth of new mediators. There's going to be a lot more interest in becoming mediators. I already see it, especially in Asia. There's a lot of curiosity. People are signing up for training. People wish to not just be trained, but to become accredited. And at least for the moment, most of this demand is coming from a desire to serve. Again, I think it's a divine coincidence that the convention is signed and ratified this year when we have the COVID-19 crisis. It's made people just come together to want to help businesses and help each other, right? So many people are signing up to be accredited, to learn how to protect each other from the disruptions. The anxiety that I've always had is that when there is this great enthusiasm and people rush into it, and there's a lot of people trying to profit from this rush into a new sector, we as someone who's more passionate about the practice than about the business, the fear I have is, are people discerning in choosing their training and their accreditation? Because it is mediation is a powerful skill, and like all powers, it can be abused. And the last thing we want is that before the mediation profession has really taken off, that it is corrupted and its name is affected, because it can, right? So that is definitely one short-term fear that I have. The good news is that what I have found, there are many lawyers, people who we used to think of as sharks, especially when things are going bad. But I have, again, because of my training work in schools, I do a lot of promotion of mediation skills with the youth. The young people are very driven by social justice. They are very driven by causes. So you see a lot of Greta Thunbergs in the social justice sector, who want to say, I want to learn this skill to help. And one of the things which I've told them is, well, if you really want to grow mediation as a young legal professional, please consider not becoming a mediator, but becoming a very good mediation advocate, becoming a lawyer who will recommend to your client collaborative problem solving rather than adversarial problem solving, and build a business model around it, right? We don't expect you to do this at the sacrifice of your livelihood. And I think there are young lawyers, there are mid-level lawyers, and there are senior lawyers who are saying, I think there is a different way to business model my practice, so that we are building bridges between businesses. And again, then what this means for businesses is be discerning in the choice of your lawyer. Inevitably, when businesses look for a lawyer, it typically means that something has happened, usually not something good, right? And be discerning, look at your lawyer and see whether he is fueling that anger and that anxiety, or is he trying to propose a pathway that is right, even if it is painful. It is wise, even if it requires sacrifice. And that is the lawyer who is acting truly in your interest and not in his own. And I do think that thanks to the convention, there will be more such lawyers coming up, and there'll be more businesses who will have access to collaborative problem solving. So that is on that theme of professionalization. And I think really at this juncture, I will end my three practical points, right? Really, in terms of enforcement, under mediation convention, not so soon, but under using the New York Convention, certainly I think in the next 3 to 5 years, we'll see a growth and this will help the transit towards the mediation convention as more states ratify it. Under the mediation process, mediation standards, I think that there will be a greater dialogue between mediators. And like Alfred has analyzed, a lot of Asian jurisdictions are among the first signatories. So I think the mediation process is going to bear a lot of Asian values in its formulation. In terms of professionalization, not just many more new mediators, but many more new mediation advocates, and businesses will need to discern this and decide with your own power as a business to choose and shape legal practice and dispute resolution practice. Thank you.
Thank you, Aloysius. Very much agree that I've seen many of my colleagues, not in the firm, but many of my fellow lawyers who likes to fight rather than to mediate. Always a problem, I would say. Now we come to the last, but definitely not the least, final esteemed speaker, Dr. Rajesh Sharma. Now, he sticks to my mind because I nearly went to the universities which he is a senior lecturer. And he's a senior lecturer in the Legal and Dispute Studies, Criminology and Justice, the Royal Melbourne Institute of Technology Universities in Melbourne, a very famous university. As I said, I nearly went to that one a number of years ago. He is also an adjunct professor at the Academy of International Dispute Resolution and Professional Negotiations, AIDRN. Now, Dr. Sharma is the director and member of the governing board of Indian Institute of Arbitration and Mediation, India, council member and the chairman of Intellectual Property Dispute Group of the Hong Kong Center of Arbitration, director of the Asia Pacific Center of Arbitration and Mediation, Associate Director of the Hong Kong WTO Research Institute, a member of the Asian WTO Research Network, and a panel arbitrator of the KCAB, the Korean Commercial Arbitration Board. Now, obviously a fellow member of the Chartered Institute of Arbitrators, an arbitration fellow at International Dispute Resolution and Risk Management Institute, and of course, panel members of a lot of institutions. Now, if I have to read on and on, it will take me hours just to read his credentials. And I don't think the audience here will be interested in me reading all his credentials. So I just stop there and pass the stage to Dr. Sharma. Thank you, Dr. Sharma. It's all yours.
Thank you, Chair, for giving such an introduction. And thank you, Thailand Arbitration Center, for organizing this conference. Even in COVID, we never thought that we will have this program, but you continued with that and you started this program and running that. That is really a good credit for you, the Thailand Arbitration Center. And particularly, I'm more interested in saying that in the first program and the first year, I joined that. And since then, every year I'm joining. And this year, as a third time, I'm joining via video conference or through the Zoom. So that is our commitment to the Thailand Arbitration Center to join this conference. The topic which I have been given, and as Aloysius said, that being a third speaker talking about the same thing is really challenge that what new thing I can add to that. But I try to give something that we have not discussed, and I want to discuss about that. Let me share, if I can, my PowerPoint. If I can. Can you see my PowerPoint? No? No, okay.
No, not quite.
I think I should have my... Okay, there's some problem, I guess. There's some firewall is stopping me to do that.
Maybe I asked THAC to
yeah, they have my PowerPoint, they can upload.
Yes.
Yeah.
So just continue
Nyapa
with
can do that.
Yeah, I just asked THAC to do that.
Thank you, Chair. This Singapore Convention is, Alfred showed the video and for the photo of the Singapore last year. I have a personal connection with this Singapore Convention because since 2015, I was involved in that as an academic, as a professional. So my contribution was that. And we were looking at this convention. So who will manage this PowerPoint? Okay, I can do that, right?
Okay.
Okay, okay. So I will give an indication when to move, so somebody can help me with that. So the Singapore Convention, the interesting part was that I was involved with that one since 2015. And the whole idea was that we wanted to take into account of getting involved in this kind of a rule making. If you look at in international rule making, Asian countries have did not have that much of involvement. The experts and professionals, they were not coming out. So all the from the New York Convention onward and every rules which you look at that, it was very much dominated by the Western world, and it was not very much like contributed from the Asian world. So that was a kind of limitation we had. So when the Singapore Convention was discussed, it was something that we from the Asia, we wanted to take part in that and get involved in that. And in that case, what happened is that Natalie Maurice Sharma from Singapore was very much interested, and she took the lead in taking care of that. And she was unanimously selected as a chairperson of the drafting group all the time. That so much so that every time, every session, she was appointed as a chair. And when it happened, everybody agrees. So it was a kind of a culmination of the whole discussion that everybody agreed that why don't we name this convention as the Singapore Convention? And that thanks to the Singapore government and the Singapore delegates to really put all their heart and soul into that, and that's why it happened. So last year when we were in Singapore as an academic, as an professional, it was like a classic historical moment for us, because we have grown up and we have studied looking at the black and white photograph of New York Convention, seeing the great people signing and looking at that, and we witness this Singapore Convention from our eyes. That was the best part, which I can say. And as an professional in this area, I will consider that one as my best experience to be there. So that was the part, my personal feeling into that one. The good point is that the Singapore Convention is coming into effect on 12th of September now, and it is already effective. So it was a very good thing. So now we don't have to worry about that when the convention will be effective or not. This is not we need to worry about. But the whole theme for our discussion now is what is there for businesses. And I want to go back to the one thing is that when this convention was conceived and it was thought about it, bringing it, when the US proposed this idea to UNCITRAL for discussion, the whole backing of that paper and that proposal was from the business side. And later on, UNCITRAL and the drafting group, they considered that whether there's a value in that or not, should we have it or not. And the many experts, many people, they did the survey among the businesses. And it is the business people who said that they want Singapore, or they want a mediation convention where they can have settlement agreement directly enforced in different country, like an arbitration award. That was their idea. It was demanded by the businesses, not by the lawyers, not by the mediators, not by academics. It is the business people who said that. And their only one idea was, they said that we are now seeing that arbitration has become more costly and it is taking more time. So we want mediation to use. Asian businesses were very much interested in using mediation. But the only problem was that the mediation settlement agreement did not have a enforcement mechanism like New York Convention, like an arbitration award. And therefore their hands were tied. Otherwise it was the response of that. So when the businesses were ready, then it was discussed that why not for the business, this kind of a settlement, this kind of a convention should be drafted. And that's the idea come, and it was there. So I want to say that today we are talking about what is there for business. I think it was started from the business, and therefore we should know from the business itself. And and that was the best part of it is there. So if it is made for the businesses, it is for the businesses to use it. But before we go there, there's a one point I say that it happened during the drafting of mediation Singapore Convention, is that this convention, before that, there was a one word, conciliation, was very much in talk. And when in 2015, when the draft started, it was started with the conciliation word, and we thought about it. And if we go back in 1970s, when UNCITRAL drafted the conciliation rules, at that time also it was discussed that what should be the word, it should be the mediation or conciliation. But what happened is that it was so dominated by Europeans and others that they said that whole world knows the conciliation much more than mediation. And therefore the word conciliation was used. And that's why you see UNCITRAL conciliation rules, you find that. Even in 2000, when the conciliation law was drafted, even at that time, everybody said that, no, it's a conciliation which is more known to anybody. But 20 years after, or I will say 15 years after, when the UNCITRAL conciliation law was drafted, when Singapore Convention started drafted over there, suddenly everybody said by 2018, they said that word mediation has now been widely used and understood by many people as compared to conciliation. So suddenly after so many years, is the word mediation has taken the center stage. And in order to give the Singapore Convention more more visibility, even the UNCITRAL has agreed and said that we have to change the name so that the people will understand it's related to mediation, and therefore the businesses will accept it. And that's how the name was changed from the conciliation to mediation. And it's not only the Singapore Convention, the main name mediation came, but related to this law, the conciliation law, which was drafted in 2000 or come effective in 2000, that law was also changed. So by one stroke, the two laws were changed at the same time. So from the businesses, I want to send a message, and I want to tell them that now they do not have to worry about this theoretical or any kind of distinction between conciliation and mediation. For the purpose of Singapore, conciliation, mediation, they are same. And that's how they should look at it, and they should not get involved in this terminology of conciliation and mediation. So that being said, the first hurdle is out. Everything, whatever they do, they use a third party, a third person to help them to resolve their dispute. That is a settlement, that is a mediation, that is a conciliation. You name it, whatever name or content you give, is the idea is the same. So we do not have to go into that. For businesses, this is same thing, conciliation and mediation, at least for the purpose of Singapore Convention. So if we can move to the next slide. If we go to the next slide. Anyone? Yeah, go to the next slide. Yes, that's right. Yeah. So what are the things that that we can see, we can get it, or the people can get it from the Singapore Convention, is that the first thing, the question we said that this convention has only been signed by 53 countries now. Is it enough, or is it more, or is it good enough to start with? My take is that I say that business people can start using the Singapore Convention even now. They do not have to worry about whether their countries have signed the Singapore Convention or not. Because the one thing was agreed in Singapore Convention is that we do not have to link this one with any seat, any country. So it doesn't matter where the mediation is conducted. That is not important. What is more important is that where the settlement agreement is going to be enforced. That was the key point. And that's why, unlike arbitration, mediation was not linked to any country. So if you are a businessman from a country which has not signed the convention, doesn't matter. As long as you are doing business with any businessman who is from the other country, or whose country has been signed the Singapore Convention, is good enough. You can be on the other earlier slide. No need to move now. When I have to move, I will let you know. Can you go back to, yeah, that's it. Stay there. When I ask you to move, then you move that slide. Thank you. So this is the point, is that whether you are a businessman from a country which has not signed the convention, still you can use this convention, as long as the other businessman has a property or anything in a convention country, then you can do that. Now, you can also look at that. As long as the country has signed the Singapore Convention, like all these 53 countries, or the Singapore has already ratified, if you have a business partner or businessman against whom you have to enforce your settlement agreement, and he's from Singapore, you can just go to Singapore and you can enforce it. There's no problem as long as possible. In that case, it is not asked that whether the person who is coming to Singapore, whether his country has signed the convention or not. There's no need to ask about that. So this is the best part for the businessmen, have to think about it. Their country has signed or not, that is not important. Where they are going to enforce, that country has to sign it. So the mediation, and another thing is that the mediation does not have to be conducted in a country which is signatory. So even if your country or any other country which is not signed the convention and you are conducting a mediation over there, still there's no problem. So the destination country is more important. And that was the biggest help which Singapore Convention has come up with that. Otherwise, you think about it, the businesses from a region like Hong Kong, Macau, and Taiwan, their status is not like a country. These are highly business active place. They have so many business partners. So if we put that kind of a condition, then Singapore, Hong Kong, Taiwan, and Macau can never sign the Singapore Convention. So the businesses from these places can never take advantage of Singapore Convention. So it will be great, loss of our thing. So that it is important for us that we recognize, for the businesses to understand that whether their country has signed or not, whether they have conducted this convention, the mediation in a convention country or not, that is not important. What is more important is that where they are going to enforce. As long as they are doing it, no problem. So the businesses are not affected with on the account of whether the convention, whether their country has signed the convention or not. So that's another talking point. Next slide, if you look at that, is that if business has to take advantage of Singapore Convention, then how it will start? Again, we have to look at that, how the Singapore Convention started. It is because of the businesses. They demanded it. So again, we have to think about who are the users. The users of ADR, users of alternative dispute resolution like arbitration and mediation, is not the lawyer, is not the mediator themselves, is the businesses who have to make up their mind. And that's why I say charity begins at home. If the businesses, they want to take advantage of Singapore Convention, then what they need to do is that they have to be the prime user of that. They have to be the stakeholder. They are the one who demanded. So they are the one, they should be the best user of that. Another way to do it is that they have to adopt a company policy, a business policy, that they will use mediation now. Earlier, they were using arbitration. Before that, they were using litigation. So the way it took time from litigation to arbitration, now it should be easy way moving from arbitration to mediation. That will only happen if we can have a policy that company will use mediation first. And that's why I say that mediation first should be the mantra, should be the idea to do that. And in order to establish, in order to use it, in order to do that, you have to first give a special instruction to your new in-house lawyers or any lawyer which you are using it. Say that our priority is mediation. We want mediation. And therefore, when you are discussing about the businesses, any negotiation is happening, put in a strategy in your negotiation. One point is an important point in your negotiation strategy, that every business deal will use, or any deal will have a mediation as a dispute resolution process. Unless until it is happening, the business will not take any advantage. Business will not get an advantage. So it has to start from the businesses to adopt the mediation first. And that will be the success of Singapore Convention. So if you move to the next slide, in that one, I divide now that business is not only the buy and sell, but I am also looking at mediation as a profession, mediation as a business. There are many mediators who are now running the mediation as a business. There's nothing wrong about it. Lawyer has a business, it's a professional services, it's everything comes under the services, and services is business. So there's no problem with that one. So if we talk about the mediation professional, because of the Singapore Convention, our hope is that there will be more jobs, because if the more companies will, or the businesses will accept that we should do more mediation, or we should use mediation as a primary dispute resolution mechanism, then in that case, more mediators will get the job. That goes without saying. However, in this whole development of Singapore Convention, there are certain unfinished business, and I call it unfinished business, because mediators and mediation ethics or their conduct can be very, very important aspect in mediation. And the Singapore Convention says that during the mediation process, if mediator acts or mediation process has been conducted in such a way that it has totally taken away the whole thing, it has totally manipulated the parties to reach to an agreement, it means there is a strong or there is a serious breach of mediator and mediation ethics and conduct, then that can be a ground for refusing the enforcement of settlement agreement or not granting any relief from there. That is a very serious standard and a very serious thing in that one. And another second one is that if there is a conflict of interest which has caused any problem, then on the basis of conflict of interest also, the settlement agreement can be rejected and it cannot be enforced. If we compare this one from arbitration, these are not the grounds for refusing the arbitration award under the New York Convention. So this is something new. However, what we have seen, and the other speakers have also alluded a little bit on that one, is that we do not have an universally accepted mediation and mediators conduct or ethics on that one. If this is institutional, then institution has a code of conduct, so we can use it for a while. But mediation can be institutional and non-institutional. So how to regulate this non-institutional mediation? Because Singapore Convention does not distinguish between institutional and non-institutional mediation. So in that case, we have to have an mediators and mediation conduct or ethics, which can be accepted globally and uniformly. If you look at the conflict of interest, again, arbitration has a conflict of interest guideline, but mediation does not. Recently, UNCITRAL and the ICSID has come up with an idea about a new code of conduct for arbitrators. And in that one, they have included mediators also. And now they are discussing about it. But the problem is, and this is my worry or a kind of a concern, is that when it comes to mediation, we are copying from arbitration. And this is what happened when arbitration was starting. Arbitration principles and policies were like copied from the litigation or deviating from the litigation. If we start and copy from arbitration, then what will happen? The mediation will lose its own identity. Now at this time, we have to establish the identity of the mediation on its own without having a dominance by arbitration. We do not need that. And if you look at the code of ethics or conflict of interest, that will not work very well, because sometimes in conflict of interest, for example, for the barristers and solicitors, the way it is drafted for arbitrators, it may or may not work for mediators. So those guidelines, which is now proposed by UNCITRAL and ICSID, where they are just using the word mediator, or as the case may be, this kind of rules will not work. We have to think afresh. We have to open a new page. We have to start thinking about which kind of code of conduct for mediator and mediation we want. And that is one we have to draft, thinking mediation as a process in that one. Similarly, for the conflict of interest also, we need to think in the same way. We do not have to copy from arbitration list or arbitration style. We have to think as a mediator, and we have to develop the conflict of interest rules for that one. Apart from that, another thing which has happened is that because the settlement agreement is now used in the court for enforcement, so the drafting of settlement agreement will be scrutinized quite well. So far, for many years, when the mediators were getting the training, there was not enough emphasis on drafting of settlement agreement. But now, since the settlement agreement will be scrutinized by the court, by different courts, then we have to have a kind of a good training for that. So I say that those who are involved in the mediators training, they also have to give or add one more component in that one in training program, where the mediators are taught, or the young mediators are taught, how to draft a settlement agreement the way the arbitrators are taught about it. A CIR, Charter Institute of Arbitrators, will not give a fellowship or the membership in that one unless until the arbitrator past the drafting of arbitration award. So the same kind of a style we have to adopt in mediator. So I say that even the mediation professionals have, as a businesses, they have a role to play, and they have to do something which I propose here. At least these two things. There are many other, but at least these 2-3 things they need to follow. If I go to the next slide, yes. Then the next slide, then in this one is like, what I said, that lawyers are also in the business. So again, the whole chicken and egg situation, it happens when the arbitration was starting, lawyers thought that they will not have a job. But very soon they realized that how much they can get a job from arbitration. So that now if we go and tell that the lawyers have, because of arbitration, lawyers will lose the job, they will laugh. Same thing we have to develop now for arbitration, for mediation. And that should not take too much time, because the lawyer should understand very soon they will have a new area of law to develop, new area of expertise to develop. And that area will come is the enforcement of settlement agreement, or challenging or assisting the enforcement of settlement agreement. This new expertise will develop. Over the period in arbitration, if we look at it, many lawyers, particularly I know one lawyer in South Africa, he's like expert in looking and advising on enforcement mechanism in Africa, because he knows very well in that one. So many people, if they have an enforcement against African party, they go to him, they ask his view only for enforcement and challenging the enforcement. The same kind of expertise can be developed by the lawyers according to the Singapore Convention, or related to the Singapore Convention, because the Singapore Convention gives the limited grounds for challenge and mediation conduct, conflict of interest. I have already told you about it. And there's another criteria has come, or is that where the settlement agreement is null, void, or inoperative, or incapable of being performed. If that criteria is also one of the grounds to challenge. But there is no enough jurisprudence or ground or like guidelines has been developed in this one. Even if we borrow the concept from arbitration, not many things has developed. So what we need is a new thinking in that area. So any new lawyers who will expertise in that one, or who will think about it, they will have an added advantage, and they will have a first mover advantage. So that's why I will say that we need to think in the lawyer's side also, as a business lawyer. So when if I move to the next slide. Yep. This one is, I also want to say that there are many third-party funding agencies has come, and because the arbitration has just started, this has a plus and minus. So instead of going in the plus and minus, let me just say that one thing is that the third-party funding is now acceptable in arbitration. So it is allowed, and it helps the parties, particularly the weaker party, or the person any company which does not have enough money to go against the big party. So the third party funding can finance their dispute resolution mechanism, or their arbitration, and they can get the decision and access to justice, or have some kind of relief in that. So the money should not be a criteria to enforce your right. The same concept has now been developed under ICSID in the mediation. They call it conciliation. In the conciliation, in ICSID, the third party funding is now allowed. So this is the one thing we see. If the mediation will grow, and the Singapore Convention will help it to grow, then all these third party funding people, those who fund this litigation or fund the arbitration, now they can fund mediation also. So any requesting party in mediation is bona fide, who has a right, who has something to sort it out, but cannot go against a big party or the financially strong party. Then in that case, these third party funding can help them to start, so that there will be mediation, there will be resolution of dispute. So that will open another area. So the third party funding, who were companies who were only looking for arbitration, now they can get a job in the mediation also. It will be possible. So the party will not be discouraged for the want of money, that how we can start, how we can run, how we can do the business, just because we do not have money. The third party funding can help in that sense. And so far as Singapore Convention is concerned, these issues were not discussed very well, but it was not prohibited. And the Singapore Convention doesn't go into how the mediation came about, where it was conducted, how it was conducted. They don't look at it. So if a settlement agreement coming after a third party finance and a settlement agreement has been resulting from there, there's no problem at all. It can be possible, and it has to be possible in that sense. It can be done. So Singapore Convention is not prohibiting, so this can be a new business for the financing companies or the third party funding organization can do that. So if you go to the next slide, that in conclusion, I just want to say that the Singapore Convention has something that it can give you everything. The Singapore Convention is giving something for everyone, whether it's a lawyers, the businessmen, the mediators, trainers, educators, or the third party funding. So it's a win-win situation for everyone. If I put it in mediation sense, it's a win-win situation. And I think in that case, the businesses should take advantage of it. And again, I say that it was started because of the businesses. So they have to take the lead in accepting it and moving it and adopting it. They cannot say that now I don't want it, because it is for their benefit, and they should only have to realize it. So with that, I thank you everyone for your time and attention. And if you have any question, you can ask through the chair or through the other channel. And if you have any question for later, here is my email. You can also use that one. So thank you very much for your time and attention. I really appreciate your time. Thank you. Thank you very much.
Thank you, Dr. Sharma. And in particular, in thinking of poor lawyer like me, that I may be out of the job if the mediation is successful. Now, I believe that we have 3 questions, actually 2 questions and 1 link to a membership. Okay. Now, it's I do have a question as well. Let's start with the first question. As I said, the questions will be answered in the order as they come in. The first question is not addressed to any of the speakers, so anyone can just answer this. Is the Singapore Convention the global the global manifestation of the emergence of Asian ways of dispute resolution, as opposed to the adversarial ways the world has been used to in cross-border disputes? Now, that's the first part of the first question. The second part is, would due process also apply under the Singapore Convention? And finally, like in arbitration, what empowers the mediator is parties' agreement. If the agreement is disputed, would the mediator also be able to use the competence principle? So any of our panelists? Dr. John, Dr. Chen, Lucius.
Well, I shall. Can you hear me?
Yes.
Can you hear? Okay, sure. Let me try to address the first one first. To be fair, I don't think this is like. I think it's like it's not a problem of egg or the chicken comes first. I think a mediation have been well adopted in many of the places around the world, and we can see there's an increase of usage of mediation in the business regime. So, like Rajesh have just mentioned, Dr. Rajesh Sharma, who have addressed very clearly that the mediation convention is simply a tool that helps the business to use this mechanism in resolving their disputes. So, of course, there can be any other ways to resolve problematic. And even if I see, they don't have to go from confronting one another. And it just comes to the global trend that starting to use mediations, and pretty much that is the spirit of why it was established in the first place. So does any speakers have anything to add to that?
We have 3 questions, so we can take one. So Alessius, you can take the second one if you want.
Rajesh, because you suffered through being the last speaker, I'm going to let you go. I'll let you do it first. Yeah, you can choose. You choose which question you want to take, and you go first.
You are so generous, my friend. Now the question about the due process. Actually, in mediation, that issue doesn't come very well, because it's the mediator who is running the show, and he's running in cooperation with the party. It's not about who has to say what. The only one time it may come, or something the mediator has not conducted very well, that he has asked only one party to say, one party to talk, one party to propose, and he shut off the other party completely, then there might be a problem in that one. So it will go more on a conduct of mediation. Another possibility might be that if one party has been given a private session and the other party has not given the private session, even if he has asked, so actually the mediator will ask about it. So I say that if a mediator is well trained, he will avoid any such kind of any kind of a situation. So the issue of due process doesn't come, because every time the mediator listens, he summarizes, he's paraphrasing, he put it them, he asks them, have I captured what you said? So if he's doing this thing properly, if mediation is conducted properly, then there's no chance, or very, very less chance of due process issue. But even it will come, then it will come under the conduct. And according to Singapore Convention, if the mediation or mediator conduct is so serious that has affected the party to reach to the conclusion, or it has gone to the root of his agreement because of that unethical behavior, because of that violation of code, because of that significant problem related to mediation conduct, then in that case you can challenge the award. So it doesn't have to be due process. Actually, the Singapore Convention is given even wider opportunity as compared to due process requirement in New York Convention. So that is quite covered in that one. So Aloysius, I leave it to the third question for you.
Thank you, Rajesh. If I can just actually, I just want to touch a little bit on all the three aspects. So on the first question, well, I think I've mentioned it earlier. I think it would be wrong to characterize the Asian way as non-adversarial, given looking at the way that the question is framed, and the non-Asian way as adversarial. So that would be a unjust frame of non-Asian ways. I think there's a lot of non-Asian ways which are also very collaborative, and there are very competitive Asian states which can look like a very adversarial process. But if I can reframe the question, do we see the Singapore Convention as a sign that there's going to be a new dispute resolution process that greater embodies Asian traditions of dispute resolution, if you can even understand what Asian tradition really refers to, right? But if there is such a thing, then I think the answer is yes. I think it's the fact that this convention is signed in an Asian jurisdiction is just a demonstration that this is a century where many Asian economies have grown in power. A lot of trade is happening in Asia. So that is one way for me to look at question one. Question two, I think Rajesh has mentioned it a lot. My own reading is that due process, there's a lot of exceptions already applied in the convention, where how you can challenge the enforceability of a settlement agreement, a mediated settlement agreement, and that is definitely one of the concerns for mediators, because as Rajesh has mentioned, one big area is this idea of standards and ethics, and standards and ethics have typically been really quite subjective and jurisdiction dependent. But that said, I don't think due process would be a big area for these parties looking to use mediation as a source of concern, because I think most jurisdictions so far, the senior judges and the politicians that I have conversed with are still leaning on the desire to preserve the flexibility of mediation and respect the cultural differences that will influence the form of the mediation. So it is exactly why mediation is going to grow in popularity. A business, a user is not going to be forced to push his dispute into that very rigid mold of a dispute resolution process, the way that litigation and arbitration is. Because as businesses, you notice, and as dispute resolution professionals, we notice too that litigated solutions, arbitrated solutions, often don't give the business client a true resolution. That's why there are appeals, even when they have won. Whereas mediation as a process can be customized to give parties the outcome that is best for them, including a transformed business relationship. So on the third point, which is why I wanted to touch on the earlier two, I actually think it's quite related to question two. So far as would a mediator ever have to decide on his own competence on the legality of his engagement? Does he have the power to mediate this? I think this is again trying to understand mediation from the arbitration and the litigation lens, which is not the best frame. In the end, mediation is really quite a different process, because the mediator is not going to be imposing an outcome, unlike the arbitrator or the judge. So he will not be called upon to rule the way that an arbitral tribunal or a judge will need to rule on his competence. More, if anything, what a mediator might need to do is to persuade and convince the parties that he is suitable because of his experience, because of his situation, to serve as a mediator for them. I mean, yesterday I was held up and I couldn't come in for the preparation because I was involved in a mediation for a company registered in Singapore but represented by Hong Kong professionals, and another company that is registered in Malaysia and represented by professionals in Singapore. You know what? No issues about my competence. It's just a question of, am I deemed the most suitable skills wise, right? So and again, this is why mediation is likely to grow, because you are not likely to face this kind of challenges that you used to face in arbitration and litigation. That will make you worry about, even if I get a good outcome, is this really a final win? Yeah. Yep.
Thank you very much, all three panelists. We do have another question. Let me just read this out. It's not addressed to any one of the speakers. Keeping in mind the number of states that ratify the Singapore Convention and the one signing the New York Convention, why should parties choose mediation over a consent award? Is there any hidden advantage? Thank you. So as I say, it's not addressed to any of the speakers. So shall I ask this time the last to go first? Dr. Sharma?
Okay. Somehow I had a hunch that you will do that. You would flip the card. Yes. The one thing is that hidden agenda. I don't see there's a hidden agenda, but it is more like a giving the identity, independent identity to mediation as a dispute resolution mechanism. When the mediation settlement agreement was converted into arbitration award, at that time there was a kind of a ideologically and philosophically there's a problem. Problem is that we are going to arbitration while everything is done in the mediation. That mechanism was used only for one purpose, so that a settlement agreement which was not enforceable before can be converted into arbitration award, and then it can be enforced through the New York route. So New York Convention route. That was the idea. So because we didn't have the Singapore type of convention, Singapore Convention at that time. So that was a viable, that was practical. So people were using it. But now we have Singapore Convention. So arbitration is okay. It's not that anything. And when we look at any country, if you look at the Singapore Convention, the countries which have signed, we were, after the adoption, like with the help of Hong Kong Mediation Center and other, we were in Papua New Guinea and in one conference, and there were many small countries were there. At that time, it was a conference, I'm talking about February 2019. All those countries who were there, they had no idea about that Singapore Convention has already been drafted and it has already been accepted. They had no idea. And they were thinking about that, what we should do. And in that case, when we told them that this is one thing has come, you should consider. And if you look at that, many of those small countries, and particularly like, Papua New Guinea, Fiji, not Papua New Guinea at that time, but the Fiji, Samoa, Palau, those were the countries involved, and we had a discussion with them from their representative, and they signed the Singapore Convention last year. So it's a knowledge and establishment also it comes. And therefore, when we have this plan to advise any government or any country who are developing ADR mechanism or ADR, we give them a package of 5. It's that if you want to develop, you want to have a good business practice, good business environment, good investment environment, what is required is that a country should adopt, of course, the model law on arbitration. They should also adopt the model law on mediation, and they should adopt New York Convention, they should sign, and they should sign Singapore Convention. And apart from that, there's a convention on international sale of goods, CISG. So it's a package of 5. If you take this package of 5, combine it together, then any country, any system can be best place for any businessman to do it, any business they want. And this is the same principle we are using it in Indian Ocean Rim Association, where we have 22 countries to do that. So this is not a competition among each other. It's giving more choice to the users that what they want to use, when they want to use. Even if we have an arbitration, litigation is still valuable. And even if we have an arbitration, mediation is still valuable. And after mediation, even negotiation is valuable. We do not have to discount that. So it is an option for the parties, what they want to use. So give them more choice. I don't see there's any advantage, any hidden agenda. Actually, it's a more opportunity, more advantage to the business people. That's my take on that.
Aloysius, you have any comments to add?
Well, if again, the way I interpret the question is that what is the hidden advantage? There is the traditional advantages of mediation. Why do you choose mediation over arbitration? Let me give you confide to you a secret, right? We have had the up protocol in Singapore, and in the time that I was there, we've had more than 10 cases coming in to use the up protocol. Of that 10, more than half were successfully settled. Of those that were successfully settled, how many used to convert it to an arbitral award? 0. So arbitrators might not like to hear this, but the truth is that mediation works. Mediation, when you get the right mediator, when you time it well, you get the right lawyers, settlement rates exceed 90%, right? It's very high. You almost always can get a settlement agreement, and a good settlement agreement, meaning that both sides see interest in performing the obligations. It's win-win in that sense, and the solution comes extremely fast. Both sides will perform the obligations typically in the settlement agreements that I've seen, and these are for large disputes, right? You're talking about 20 million US and above. Obligations are performed within 8 weeks, which is about the time that you take to convert your settlement agreement into a consent arbitral award. So they've never needed to convert it to a consent arbitral award. So that is that advantage, that you condense a protracted arbitration hearing that could take upwards of 5 days, and that's very fast, right? into maybe at most a 2-day mediation because it's international and it's complex. Otherwise, mostly 1 day. You get a solution within 8 weeks, usually less, compared to an arbitral award that is then challenged and you have to find ways to enforce it even after you have won. These are not hidden advantages. These are obvious advantages, and businesses know this. A lot of progressive law firms know this, and they are already starting to morph their dispute practice to include mediation advocacy. As Rajesh has said, even third-party funders have looked at mediation more than arbitration because it helps to mitigate their funding risks. So this is why even without your jurisdiction having ratified it, mediation is for the business user really quite an obvious choice. Yeah.
Thank you, Lucius. Alfred, any comments to that?
I finally truly experienced the part that where former speakers have talked about the privilege of speaking fast, because it is very, well, they have explained it very comprehensively that I think, so from the way I see it, that like all three of the speakers, including myself, has mentioned, like arbitration and mediations are not in competition. There are always some clients prefer mediations, which is they can have a higher self-determinations, saving the time, and some would prefer arbitration, which has a judge to help you in deciding, issuing a judgment. That helps parties to resolve their problem. So the idea of that is allowing parties have better options. In the previous time, like we can see some parties, they might stick to arbitration due to traditional, or it was the only way they can see the disputes, the cross-border disputes can be resolved. They value the idea of mediation. However, the settlement agreement was not internationally executed or enforceable. Therefore, they have to go back to arbitration as their second option to resolve the disputes. So I think now when mediation, the convention has come up, that ease of some of the worries they have for whether it can be executed cross-borderly, and meet up will still be a mechanisms if mediation convention was questioned on or worried by some parties regarding the ratification of different status, which is still in the lower number. So we can see there is a development of or more collaboration between arbitration and mediations. And so this is what I sum up. Thank you.
Thank you very much. I know that our time is up, even though we have a last questions that come in. So for those who want to stay and listen to these last questions, you're more than welcome. So I will just read out this very last question. Could you elaborate something about the certificates that have to be issued after the mediation in order to follow the Singapore Convention? Once again, it's directed to all the speakers. So being fair to Alfred, you can start first.
I'm not quite sure the certificate that was mentioned about, but as far as I understand, like that parties have to provide a affidavit that the agreement was drafted in a good formality, and perhaps it was undergone a standard procedures that was acceptable, and so there is the idea of having an institute to safeguard that procedures was fitting into the criteria of Singapore Convention was required. So I'm not sure the certificate that was addressing to, but there is a certain way of monitoring that kind of procedures. Other speakers?
Any comments from Aloysius and Rajesh?
If you want me to go first, or
Yes, why not?
okay. In the Singapore Convention, there is no requirement of certificate of mediation. The only thing is required is that the settlement agreement must be resulting from mediation. So the only thing party have to prove, or those who go for enforcement, they just have to prove that this settlement agreement is a result of mediation. So how to prove that there's a result of mediation? That can be done by various ways. If it's an institutional, then they can get its certificate from institution. If it's a private, then the mediator can say that. And actually, this does not have to be appended to any settlement agreement. Mediator does not even have to sign it, or even if he signs it, that's okay. Even the mediator can send an email saying that this settlement agreement is done by through the mediation, and I was any other evidence also justify. And during the an Australian delegate, you pay fee, you see.
We're having some sort of rather bad reception from Dr. Sharma's end. Aloysius, do you want to go first?
I was going to be lazy and say everything that Rajesh and Alfred said, and technology didn't allow me to do that. But anyway, yeah, don't worry. So Rajesh, are you back? Do you want to finish your comment?
Yeah,
I think you should.
So
yeah.
that's what I was saying, that during the drafting, this question was asked. And the whole idea was to make it as easy as possible for the party to prove that this settlement agreement has come out of mediation. So one example which was given, I said that Australian delegate proposed that if you don't find any certificate, mediator is not signing, mediator is not sending an email because he does not want to put his name out, then you just show that you paid mediation fee to a mediator. Even that can be a good example or a good evidence to accept that this settlement agreement has come out of mediation. So basically, any way you want, any way you can prove that there was a mediation and this is the settlement agreement which in the mediation.
Let me just jump in at this juncture and say that I think what Rajesh mentioned is, if I can summarize it, the idea for the drafters of the convention is to have the certification of this mediated settlement agreement be kept as simple and accessible as possible. Again, that is the spirit of the drafters of the convention. How it will happen will definitely depend on how the different jurisdictions which ratify the convention thereafter legislate as to what their model mediation law is going to be and what they will deem acceptable. Hopefully, the ratifying jurisdictions keep to the spirit of the writers of the convention, and you don't need to go through a complicated, tedious certification process. It really is just some kind of evidence that this is a mediation that is covered under the convention, and the settlement agreement is flowing from this form of mediation. Yep.
Thank you. Any further comments to add, Dr. Sharma, before you drops off?
I already gave my point on that.
Okay.
It's just a flexibility is a key here, nothing more.
So that brings us to the end of this conference's presentation. And thank you, Dr. Chan. Thank you, Aloysius. And thank you, Dr. Sharma, for sharing your thoughts with us. I must thank all the audiences who stayed with us until the end. I see that we still have 56 audience on the list. Usually it was just dropped off to close to 0 after the designated time. So if you have any further questions, I'm sure that the speakers, the panelists will be very happy to answer all of them. And finally, a thank you THAC for organizing this international arbitration webinar. This is very entertaining, and as a moderator, I myself learned a lot from it as well. So thank you very much for participating, and I look forward to seeing all of you next time.
Thank you, Chair.
Thank you.
Thank you.
Thank you. Bye-bye.
Thank you,
Thank you,
Ronald.
Ronald.
Take care.
Thank you, other speakers.
Thank you.
Bye-bye.
Have a nice evening, everyone.